till the end. In Jesus' name I pray.
Amen.
Amen.
Thank you. I hope you had a good night rest, and we are here to continue from where we left. Yesterday, we did introduce ourselves to the concept of law. We tried to define law. We looked at the principles of law, the purpose of law, and the various classification and sources of law. We want to continue today, unless someone has a question on the areas that we covered yesterday, before we move to the other area. And also, I had uploaded the assignment. I hope you have been able to access it, the assignment I gave yesterday. Any question, any follow-up question on what we discussed yesterday that maybe we need clarification on? Okay, there seems to be none, then that means we continue. Today, we would be looking at two areas. We'll be looking at the law of persons, and then we'll look at the court systems in Kenya. And should time allow us, we'll then look at the aspect of public law, so that from next week, we'll be looking at the mercantile law, where we'll begin by looking at the law of tort. So we'll try as much as we can to see if it's possible for us to do the three areas. If not, we will still be able, I think we are still on time, even if we don't meet tomorrow as we had planned earlier. Remember, we had said we'd meet on Friday, but I think we are still on time. We'll be able to catch up with the time that is remaining. So we start by looking at the law of persons. We will start by looking at the law of persons. Just a minute, sure. The question we are asking ourselves is, who is a person? What is a person in law? And once we get to know what is a person in law, then we are interested in trying to understand how does the law treat a person. And the various classification of persons is also important, so that we understand the different types of persons we are dealing with, and then get to know how the law treats them. Now, the importance of us understanding how the law treats a person is important because it would determine the kind and the nature of relationship that is going to exist between persons. Remember, in business, we are talking about relationships. When we are talking of interactions, yesterday we said that the law is there to provide a guidance to human behavior. Now, this guidance on human behavior is essentially what defines the level of relationship or the type of relationship that they are going to have. And so we want to see how the law treats different kinds of persons, so that once we get to know how the law treats these different types of persons, we will be in a position to understand the kind and the nature of relationship that can be established between these different types of persons within the legal confines or within the provisions of the law. This is why the study of the law of persons becomes important to us. It helps us determine the nature and the type of relationship that is going to exist between different types of people within the legal framework. Remember, we say that one of the principles of law is that it must be enforceable. Enforceability is important. And then two, it's about a specific community. Now, enforceability of the law and the application of the law to a specific community is significantly influencing the aspect of the persons. And so when we get to know the person we are dealing with, then we'll be able to tell the extent to which the law, as it applies into that particular relationship, would be applied. You realize that the law is applied in different ways to the different persons that we are going to address. And so it is important for business persons or for business professionals to get to understand this aspect of the different types of persons and how the law handles these people. What is a person? In law, a person is defined as an entity or a being which is recognized by law as having certain defined rights and obligations. It is either an entity or a being. A being is human being, by the way. When we talk of a being, then you're talking of human being. So a person in law could either be an entity. An entity is an organization. It can either be an organization or an individual, a person who is recognized by law as having certain defined rights and obligations. And so it is important, this is important. The aspect of one having defined or certain defined rights and obligations in law is what establishes the existence of a person. And so this can be either an entity or an organization or an individual. Now, such entity would be considered to be a legal person when they exist and they have their defined rights and obligations outlined by law. Then they are considered to be a legal person. And so our concern is to try and understand how the different legal systems accord different legal personality to persons. And in this case, we are talking of entity or a being. And so it shows that we have these two types of persons. A person as an entity or a person as an individual being, human being. And so we are talking of artificial persons and natural persons. Artificial persons being the entity aspect and natural person being the being aspect. And so we have artificial persons and then we have natural persons. This is what the legal systems accord to different types of persons. Now, the Kenyan law attaches personality to a human being on birth and ends it with the death, so that dead persons are no longer the subject of legal rights. It is important to understand that in the Kenyan system, the legal personality is attached to human beings at birth, and it ends with the death of such a person. So that after the death of the person, then the person is considered not to be existing. It will never be a subject of any legal rights. And so a person dies. When a person dies, all their legal rights would also die. Legal persons are generally classified into two. We have the artificial persons and the natural persons. An entity which is recognized as a person is said to have a legal personality. It is, when we talk about an entity being recognized as a person, it simply implies that the person he has a legal personality. What do we mean by having legal personality? He has the attributes which are recognized by law as constituting a person. So when an entity has attributes which are recognized by law as constituting a person, then it has a legal personality, and as such, then it becomes a person in law. So we have examples include human beings who are natural persons and corporations that are artificial persons. They have legal personality to the extent that they each have their own rights and obligations that are recognized by law. Individual persons, natural persons, human beings have their own rights and obligations that are recognized by law. Now, the same is true about entities or artificial persons. They also have their own rights and obligations as recognized by law. And this is what grants them the legal personality. This is what makes them exist as a person in law. And this is what then enables the law to regulate their behaviors, to provide a guidance on their conduct, either as an entity or as a person. How they are going to behave, how they are going to relate with one another is then defined by law. This is what we refer to as a legal personality. The extent to which they can establish relationships, the extent to which they can exist within a given relationship is defined by law. This is what essentially grants them their rights and obligations. You see, we can only have rights and obligations where we have relationships existing, different types of relationships. And in this case, we'll be focusing on business relationships. And so we want to see how the law treats different persons, either as artificial persons or natural persons, such that they are able to establish specific relationships, specific commercial relationships or mercantile relationships. So we start by looking at artificial persons. Now, artificial persons may be corporations or unincorporated associations. Two types of artificial persons. They're either corporations or organizations. Corporations are defined as an association of persons bonded together for sole particular object, usually to carry on business with a view of making a profit. When they are bonded together, we have individuals, association of persons bonded together. Again, remember, we are talking of persons and not human beings. It could be an association of another artificial persons, a group of artificial persons, or it could be an association of natural persons. The thing here is they are bonded together for a sole particular objective. Then it becomes a corporation. And we are saying, in most cases, this sole particular objective is usually to carry on a business with a view of making a profit or with a view of realizing specific objectives. So when they come together, they are bonded together in that association, and they have a sole objective, which is either to pursue profit, either to pursue specific objectives, then we are referring to that as a corporation. Corporation has legal personality of its own, distinct from that of its members. That is another important aspect that we need to understand, that corporations have legal personality that is distinct from that of its members, the members that constitute it. For instance, when you talk of a company, we have the owners of the company. What we are saying here is a company then has got its own legal personality, which is distinct from that of the directors or from that of the shareholders who are constituting that particular company. And so then with regard to it as a person, it has the rights and obligations like any other person would have rights and obligations under law or as defined by law. The individual members have rights and liabilities of their own apart from those of the corporation. That is another important aspect of corporation. And this is what we call separate, separate entities. The owners, the individual members, the individual owners, the shareholders have their own rights and liabilities, rights and obligations, which are different from the rights and obligations of the corporation. So the members, the individual members, are regarded as a separate entity from the corporation. And so when we get into a relationship with corporations, we are not getting into a relationship with the individual members, but rather we are getting into a relationship with a specific organization, with a specific entity, which is equally a legal person. So we are getting into a relationship with a totally different person, different from the members. The corporate body is different in that it has perpetual succession, it never dies, and has a common seal by which to authenticate its act. Human beings have their signatures, have their thumbprints, which would be essentially useful in authenticating any act done or committed by the person. What about the corporations? We're saying the corporation a corporate body or a corporation is different in that it has one perpetual succession. You know, unlike law, unlike in national persons that provides a definition of, unlike a natural person who is considered to be alive at birth and ceases existing at death, we're saying that for corporate body, for artificial persons, they are perpetual succession. Their existence is perpetual. And in other words, their existence moves into the unforeseen future. They never die. They continue existing because their existence as a legal personality is independent of the individual members constituting it. They have a common seal, and this common seal is what actually authenticates any act committed by the corporate body. The members may change, but the corporate body does not change. That is what we refer to as perpetual succession. Members come and go, but the corporate would remain. The corporate body would always remain. A corporation is an artificial person composed of one or several persons and is recognized by the law as having a separate personality from its human members. Now, this particular aspect is important in establishing the nature, the extent, and the kind of relationship that we can have with corporate. It should be noted that corporate bodies, being artificial persons, they are composed of one or several persons, but it is recognized by the law as having separate personality from the human member, from the one or two persons constituting it. And so the person and the organization are two different entities. Now, this is better explained in the case of Salmon versus Salmon and Company Limited of 1897. Of course, this particular case is important as we move to business law 2, because we'll be looking at companies. Business law 2 is mainly companies. And so the existence of a company and in the determination of the kind of relationship, the nature and the extent of relationship that one can have with a company, with an artificial person, then this case of Salmon versus Salmon and Company Limited comes up. Getting to know the existence of separate personality between the company and the individual members, then the Salmon versus Salmon and Company Limited case comes up. It is a critical case that helps to define the legal, the existence of a company as a separate legal personality from its members. And so the act of the members is not the act of the company, and the act of the company is not the act of the members. The two of them are two separate entities. They are dependent on each other, but the two of them have a separate legal relationship when it comes to business, when it comes to the conduct of the affairs of the company. And that is the Salmon versus Salmon and Company Limited. You have different types of corporations. There are basically two types of corporations. We have the corporation sole, and we have the corporation aggregate. Now, the two types of corporations, corporation sole and corporation aggregate, differ both in the manner of their creation as well as their membership and in their ways of operations. Those are the areas that differentiate the two, the corporation sole and the corporation aggregate. Now, corporation sole is one which consists of one human member at a time, such member being the holder of an office which is held in succession by one person at a time. Now, there are instances where we have offices that are created and only one person can hold that. But then that office is considered to be an entity on its own. A good example is the office of bishops. You can only have one bishop for a particular diocese, one person, one bishop at any point in time. We cannot have two bishops for a diocese. We cannot have two popes, for instance. We only have one pope. We only have one one general conference president of the SDA. We cannot have two of them at the same time. We only have one president in the entity, in the institution of presidency in any country. We cannot have a country with more than one president. It can only be one at a time. And so that is what we call corporations. Those entities which consist of one human member at a time. The human member, the human being will be a holder of an office which is held in succession by one person at a time. They are creatures of the common law. Corporation souls are creatures of the common law. There cannot be more than one holder of such office at the same time. When the holder of that office dies as an individual, the office will never die. The office will never die. Remember in Tanzania, sometimes back, when President Magufuli died, the presidency didn't cease. The presidency had to continue. The other day, we had our own CDF passing on, but the office remained. The CDF died, the office remained. We have another CDF right now. And so this is what we refer to as corporation soul. This is what we refer to as a corporation soul. The office never dies even when an individual dies, and the office will continue in existence with a successor coming in. There's that perpetuity. Other corporation souls are created by constitution or by act of parliament, like the office of the president is created by the constitution. The office of the public trustee is created by the constitution. Some acts of parliament have come up to establish specific offices of public trustees, which are considered then as corporation soul. Then we have corporation aggregates, and in this is where we have most organizations falling in. Most corporations are corporations aggregate. In corporation aggregate, there exist two or more members at the same time. There will exist two or more members, same level, same time, at the same time, they would be there. In Kenya, we have two types of corporation aggregates that are in existence. We have the statutory corporations, and then we have the registered companies. For the purposes of business law, we'll be interested in registered companies, and this is what we'll be discussing in detail when it comes to business law too. That the second category, the registered companies. However, we also have statutory corporations that are all equally in existence. It is important we get to understand the rights and obligations of statutory corporations, which are then defined or created by specific act of parliament that brings them into existence. And then we have registered companies. Again, the rights and obligations of the registered company are well defined within the provisions of the Companies Act of 86. It makes such provisions that will now define their existence, their rights and obligations. When you look at CAP 486, the Companies Act, then you will find all those provisions. How are corporations created? It is important that we understand the process of creation of corporations. We have two ways of creating corporations. It can either be created by an act of parliament. We have those corporations that are created by the act of parliament. These are mainly the statutory corporations. The first category we talked about, the statutory corporations. The statutory corporations or the state corporations, statutory corporations comes from the word state. There are state corporations that are created through an act of parliament. An act of parliament brings them into existence. The act of parliament then defines their rights and their obligations, defines their objectives, defines the way they are going to operate. And as such, then, the same act of parliament would then come in to regulate their behaviors, would provide a guidance as to how they are expected to behave at that particular time or at any point in time when they are undertaking or carrying out any business transaction. And so the Act of Parliament then regulates the kind of relationship that they can get into. And in this sense, then it defines the kind of activities they can engage in, the kind of engagements that they can have with other parties, the kind of business transactions that they can engage in. So that if they go beyond that, then they are assumed to have operated beyond their powers, what we refer to as ultra vires. And when they operate ultra vires, when they operate beyond the powers granted to them by the specific act of parliament that brought them into existence, then they are deemed to have gone beyond the powers they have. They are deemed to have done something that is illegal, cannot withstand the test of law. And so they have to operate within the confines of the law. Some of the examples of the corporations that have been created by Act of Parliament includes Kenya Railways, Kenya Airways, Kenya Meat Commission, Pirateran Bar of Kenya, Coffee Board of Kenya, Kenya Ports Authority, Kenya Airports Authority, Kenya Civil Aviation Authority. We have Telcom. Those state corporations, the parastatals, all the parastatals are created through the Act of Parliament. So they're in the first category. Then we have the second category, by registration. Corporations can be registered or can come into existence through registration. And of course, depending on the type of corporation we are talking of, if it is company, then they are registered under Companies Act. If it is a cooperative society, then they are registered under the Cooperatives Act. If it is a partnership, they are equally registered under the Partnership Act. And so companies, the second type of way of creating corporate bodies is through registration. Registered companies are created by registration under the Companies Act. Registered cooperative societies are created by registration under the Cooperatives Act. Registered partnerships are equally created by the registration under the Partnership Act. These are also known as limited companies. Those that are created under the registration, those that are created by registration under the Companies Act are known as limited company. They come into existence by complying with the provisions of the Companies Act 486. And of course, cooperative societies would also come into existence by complying with the provisions of the Cooperatives Act. A limited company may either be private or public limited company. It is important we understand that. And of course, in business law too, we'll be discussing these ones in detail. Then we have the unincorporated associations. Remember, we said artificial persons can either be corporated entities or corporations or unincorporated associations. An incorporated association is one which has no corporate status. It is one which has no corporate status, that is, it has no legal personality and cannot therefore own property or enter into contracts or sue or be sued in its own name. So we have those unincorporated entities or unincorporated associations. They have no corporate status. They have no legal personality, and therefore they cannot own property, which a corporated entity can do. They cannot enter into any contract. They cannot sue or be sued in their own names. They include associations such as clubs, societies, trade unions, partnerships, etc. It's important we understand a bit about trade partnerships. These are are incorporated associations. In Kenya, all partnerships are formed in accordance with the Partnership Act, Cap 29, Section 3, subsection 1 of this act defines a partnership as the relationship which subsists between two or more persons with a common view of a profit. And therefore, in a partnership business, two or more persons jointly run a business. The liability of the individual partners in partnership is unlimited unless the partnership in agreement provides for any of such limitations. Unlike in the registered companies where the liability is limited, for the partnership, the liability of individual partners becomes unlimited. A partnership consisting of not more than 20 persons, except in certain cases, a partnership would normally consist of not more than 20 persons. It is important we understand that partnership cannot exist of more than 20 persons ordinarily as provided by the Partnership Act, Cap 29. However, in certain situations, it may go beyond that. But, when there are no exemptions, then they would always go up to 20. But in some cases, there are exemptions like practicing solicitors, professional accountants, members of the stock exchange. They may exceed the 20 number of partners. Now, normally the number of partners in a partnership business would vary from 2 to 5. That is a normal occurrence, 2 to 5. Now, in the case of banking businesses, the number of partnership is normally limited to 10. The name of partnership as provided by law must be registered first under the registration of business partner or under the registration of business names Act Cap 499. It has to be registered first under the registration of business names Act Cap 499. And then we have trade unions, which is an association of laborers. Professor Webb defined trade unions as a continuous association of wage earners for the purpose of maintaining and improving the condition of their employment. And then we have the natural persons. It is equally important we get to understand how does the law treat the different natural persons. Now, we've looked at artificial persons, and you can see that the law treats artificial persons differently depending on the kind of a person, whether it is incorporated or unincorporated. When it comes to corporations, the specific act that brings it into existence will then define how it's going to relate with others. It will define the kind of activities they can engage in, so that when you want to get into a contractual agreement, you need to understand that the contractual agreement we are making with this particular person is legally binding, is valid, can be enforced, and is within the powers granted to that particular person. It is within the rights of that person, and it is also within the obligations of that person as defined by the law that brought it into existence. That is very important. Otherwise, you might end up in a business relationship that the law does not recognize, that is considered to be null and void. And any relationship that is null and void is a relationship that cannot be enforced. And so it now negates the principle of enforceability. And as long as the principle of enforceability is lacking, then it's not law. The law then cannot treat it in any manner. It ceases existing. And so it is important you understand the kind of an entity you are dealing with, the person you are dealing with, the kind of personality as granted by law, and whether you are getting into a properly constituted relationship, because that will define how you're going to move ahead in that relationship. It's important you understand. Then we have natural persons. We have different categories of natural persons. We'll look at a few of them and try to understand what the law provides so that when we get into a relationship with all these different types of natural persons, we know that we are getting into a properly constituted relationship. Because any relationship that is improper is considered to be void, is considered to be null and void. It cannot exist. And so if you enter into a relationship with a relationship that the law itself does not envision its existence, then there's no relationship. And it means at the end of the day, remember we said every decision we make as a business has a legal repercussion. It will affect the operation of business. So it is important we understand the different types of persons, natural persons. We have the first one, the minors. Minor is also known as an infant. An infant or a minor is a person who is below the age of majority. And it is important that we underscore that when we talk of the age of majority, different countries have different ages of majority. In Kenya, the age of majority is 18. As much as there is a push to bring it down to 16, as things stand right now, the age of majority is 18. In some countries, it's 16. In some countries, it's actually 24. You go to Rwanda, the age of majority is 24. So anyone below the age of 24 is considered to be a minor. And so the law would take its natural course in such instances. There are rights and obligations that the law bestows upon a minor. There are some relationships that one cannot get in minor in the business context. And so we need to know, we need to understand what does the law provide for such. A person who has attained the age of majority is a major or an adult. Now, the Age of Majority Act, Cap 33, provides that a person shall be of full age and cease to be under any disability by reason of age on attaining the age of 18 years. And that means below 18 years, there are certain disabilities that the person has as a minor. And it is these disabilities that defines the relationship that you can have with them, even as a business person. You know, the infants can sue and be sued in tort, but the age of criminal responsibility is at the age of 18 years. And therefore, you know, an infant, for instance, is not eligible to vote until he has attained the age of 18 years. And it is at that time that their names would appear in the register of voters so that they can register them as a voter. This is provided for under Section 43, subsection 1 of the Constitution 2010. Of course, the Constitution of Kenya considers that an infant can own personal property. They can own personal property, but they cannot enter into any relationship relating to those properties. They cannot sell, but they can own. There's a difference between owning and disposing. Now, as regards the immovable property, an infant's name can be entered in the register as the owner of a registered land as provided by Section 113, subsection 1 of the Registered Land Act, Cap 300. Now, with the exemption of this right, an infant cannot own immovable properties. Now, minority is a disability in the sense that there are certain things which a minor cannot do or be made liable for. You know, for instance, a minor cannot get a driving license. So if you are going to engage a minor as a driver, the minor cannot obtain a driving license. So there's a disability. You therefore cannot hold them liable for any accident that is going to occur. And you know that as a repercussion with the insurance guys. Now, special rules governing minors in respect of contracts, property, succession, liability, torts, and other areas of law are dealt with or are handled as per the provisions of every law. So when we talk of law of tort, there's a provision that handles minors when it comes to tort. When we are talking of contract, there are also specific legal provisions that handles the aspect of minors. And so as we'll be looking at that, we'll be trying to know. For instance, if it is a contract of employment, what does the law say about minors? How and to what extent can we engage with minors when it comes to employment aspect? When it comes to law of contract, we'll also look at what does the law provide, the law of contract provide for when it comes to engaging in a contractual agreement with minors. And so specific laws would provide us with a direction on how we are going to deal with them. That is very important. And so when we'll be looking at that, we need to understand what are the liabilities, what are the disabilities that the law grants on the minor, so that before we engage with them, we should already know the impact of such relations. Are they going to be valid or they are going to be void? Another aspect of minors is legitimation. A legitimate child is a child who is born within the wedlock, who are those who are lawfully married. An illegitimate child is a child who is born outside the wedlock. And therefore, legitimation becomes a proper process that makes the illegitimate child becomes legitimate. So legitimation is the process by which an illegitimate child becomes legitimate. It is brought by the subsequent marriage of the parent of a child who was born illegitimate. That is very important. And so a child born illegitimate at the subsequent marriage of the parents, then they become legitimate. The Legitimacy Act, Cap 145, provides that an illegitimate child can be legitimated by the subsequent marriage of his parents. Section 5 of this act provides that an illegitimate person, after becoming legitimate, is entitled to take any interest, one, in the state of an intestate after the death of legitimation. We'll be looking at that. That is about succession law. And so we'll look at that. Or two, under any disputation coming into operation after the date of legitimation, or by descent and an entailed interest created after the date of legitimation. So those are issues we need to understand, because they're going to affect our business as we move forward. We are going to have partners, we are going to deal with companies and partnership, we are going to deal with registered companies, with shareholders, and shareholding will impact on our relationship. And one of the aspects that comes in is the aspect of succession. At the death, at the demise of a shareholder, and the shares are transferred to a child who has, an illegitimate child who has been legitimated, who has gone through the legitimation process. There's a way the law handles that, so that we don't assume, we don't make a lot of assumptions that would end up costing us dearly at the end of the day. Then there's also adoption. Adoption is the process by which parental rights are transferred from the natural parents of a child to other persons authorized by it. An infant can be adopted so that the relationship between the child and the adopter is similar to that of parent. The adoption in Kenya is governed by the Adoption Act, Cap 143. It is important to understand that an adoption order has the effect of vesting in the adopter all rights, duties, obligations, and liabilities which were previously vested in the parents or the guardians of the adopted child. So the person, through the adoption process, when adoption order has been granted, then all those rights, all those obligations that were on the previous guardian or parent of the adopted minor are transferred to the adopter. And so they remain as such, so that those rights and obligations now are transferred to the adopter. And after adoption, the adopter becomes responsible for the custody, for the maintenance, and for the education of the adopted child. He has a right to consent or assent to the marriage of the adopted child. The adopted child is much in the same position as a child born to the adopter in lawful wedlocks, even in matters of family settlements and inheritance. It's important we understand that. The infant who is adopted will have the same rights to the adopter's property as if he were his real child. So that has a serious implication on the law of succession, and of course, in how we are going to relate with that. The adoption process is important. We understand that the resident magistrate court has the jurisdiction to hear and issue adoption orders, where all the consents required have been given and where the adoption case is paid for. Where in some cases, the High Court makes adoption order. And any person who is aggrieved by making or refusal of an adoption order can appeal to the Court of Appeals. Then we have guardianship. You know, generally an infant's interests are normally protected by his parents. A minor's interests are protected by the parents. But then what happens when the infant doesn't have parents? When the infant doesn't have a parent, when the minor do not have parents, then the issue of guardian comes in. Where the minor does not have a parent, there's a need for guardian to play that role. That is where guardianship comes in. The law relating to guardianship and custody of infants is contained in the Guardianship of Infant Act, Cap 144. And Section 3 of the Act provides that 1, on the death of the father of an infant, the mother shall be the guardian of the infant, either alone or jointly with any guardian appointed by the father. Now, when the guardian has been appointed, then the court may appoint a guardian to act jointly with the mother. In instances where no guardian has been appointed, then the court may appoint a guardian to act jointly with the mother. 2, on the death of the mother of an infant, the father shall be the guardian of the infant, either alone or jointly with another guardian appointed by the mother. And when no guardian has been appointed, the court may appoint a guardian to act jointly with the mother. And number 3, where an infant has no parent, no guardian of that person, and no other person having parental rights with respect to it, then the court, on the application of any person, may appoint the applicant to be the guardian of the infant. It is important that we understand that, because it's going to affect even the business relationships that they are going to enter into. Then the second category of person, that was the first category of minor, and it's important we look at all those legal provisions that affect the relationship they get in. The second category of natural person are the mentally disordered person. Mentally disordered persons are also known as persons of unsound mind. It's important we understand, what does the law provide for their existence, for their relationships and the likes. Now, like a minor, a person, mentally disordered person or a person of unsound mind, lacks that capacity to do certain things. The insanity affects a person's legal capacity in many ways, and therefore it imposes certain disabilities on the person. It is important we understand these disabilities, because we might get into a relationship with them, and yet they have these disabilities. And you see, any relationship that is entered against disability is a relationship that is considered to be null and void. The law cannot enforce that relationship. And so in business transactions, it is important that we understand these relationships. Are we getting into a relationship with the person with any disability or limitation, or we are getting with a person with no limitation insofar as getting into such relationship would be concerned. The law recognizes that such persons may be exploited or taken advantage of, and that some measures of protection is as required. And so these measures of protection is what we need to understand. Are we dealing with a person who has limitations and therefore is put under certain protection by law? And you see, if we get into a relationship with persons who are under certain protections by law, then that relationship is considered null and void. The Mental Treatment Act, Cap 248, provides some measures of protection, treatment, care of mentally disordered persons, and the custody and the management of the property of such persons. And this is what is important for us. What are these protections? When it comes especially to the management of properties of persons of unsound mind. This would also entail organizations where they are shareholders. What does the law provide? What are the protection measures granted to them? A mentally disordered person is subject to certain disabilities. These are as under 1, he does not have a right to vote. Person of unsound mind does not have a right to vote. Because the mental status, the unsound mind would impose certain disabilities on the person, and therefore it affects his judgment. And a judgment that is done with hindrance, without free will, is considered to be one that cannot be enforced by law. A marriage contracted by any person of unsound mind is not valid under the Matrimonial Causes Act, Chapter 152, Section 14, subsection 1, paragraph F. Insanity is a defense to a prosecution for any crime, although the accused must prove that he was insane at the time the crime was committed. And so a person of unsound mind may not be prosecuted for criminal offenses. It becomes a defense to a prosecution for any criminal offense. Any crime, a person of unsound mind cannot be prosecuted. As long as there is evidence, there is a proof that the person at the time of committing the crime was insane, then he or she cannot be prosecuted. The contracts of mentally disordered persons are voidable at the option of the mentally disordered person. That is very key for us. If we enter into a contract with a mentally disordered person, then we need to understand that such contracts are voidable at the option. When the person of unsound mind elects to void a contract, voiding a contract simply means relenting on it, turning their back on the contract and disowning the contract. That is what we mean by being voided. It can be disowned, and when it is disowned, then it cannot hold. You cannot pursue the performance of that particular. So the law provides that the contracts of a mentally disordered persons are voidable at the option of the mentally disordered persons. They can elect to void it, they can elect to disown it, and when they elect to disown it, then that. And so we need to understand how the law treats persons and sound minds. Now, the Mental Treatment Act, Cap 248, requires that a person of unsound mind must be admitted to a mental hospital. Any such person may be received as a voluntary patient into a mental hospital if he has attained the age of 16 years and above. Any person under that age can be received as a voluntary patient if a parent or guardian is so desirous. And of course, a magistrate can also make a reception order to admit a person of unsound mind into a mental hospital. Then we have the provisions of the law of persons on marriage. It's also important you understand what does the law provide. Marriage is said to be a contractual relationship. And that is important for us to understand, that it is a contractual relationship viewed as a contract between a man and his wife. And this contractual relationship gives rise to certain rights and duties. Gives rise to certain rights and duties. The law of Kenya recognizes the following 4 systems of marriage: 1, statutory marriage, or what we refer to as civil marriage, where go to either the Attorney General's office and receive the marriage certificate, or you go through the church, the Christian aspect. It is important that you understand that the marriage that is done in churches is under statutory. So statutory marriage can be presided over either by the Attorney General's office or by authorized individuals, especially religious leaders who are authorized to conduct such and issue signed marriage certificates on behalf of the government. So those are statutory marriages. They are registered with the government, and they are done in accordance and in compliance with the provisions of the Marriage Act. Then we have the customary marriage. Basically, this applies to those who subscribe to specific cultures. Then they can do customary marriage. Then we have Hindu marriage for those who are adherents of the Hinduism. Then we have Islamic marriage for those who are adherents of Muslim Islamic religion. They'll always follow the Islamic marriage. And so what is important for us to understand is what are the rights and obligations given to or arise when we are married. The parties to a statutory marriage must each have capacity. And this capacity is determined by their age, sex, and marital status. Now, except in the case of a widow or of a widow, marriage age is generally a person below this age can only contract a marriage with the consent of the father or the mother in the case the father is dead, or of a person of unsound mind, or when the father is absent from Kenya. Now, as regards sex, the parties to the marriage must be male and female. That is very clear in the Kenyan Constitution. The persons of same sex have no capacity to marry. Now, regarding marital status, each of the parties to the intended marriage must be single. A marriage is null and void if it is celebrated while the former husband and wife of either party is still alive and the previous marriage is still in force. And so those are the legal provisions. The other important aspect on natural person is on citizenship or nationality. It is important we define the citizenship or the nationality of the persons we are dealing with, because this has a lot of legal repercussions. Nationality or citizen refers to a person's political allegiance to some state in return for which is afforded protection by that state. Now, each independent state has rights to determine who are the nationals or the citizens. Now, the law relating to citizenship and nationality of Kenya is contained in the Constitution of Kenya and the Kenya Citizenship Act, Cap 170. We have provisions of the law of persons on acquisition of citizenship, and is, how do one acquire citizenship? We have 4 main ways of acquiring citizenship. 1, by birth. One can acquire citizenship by birth. Now, citizenship by birth is determined by the fact of being born in Kenya, and also by citizenship of a person's parents or grandparents. Now, the law generally provides that all persons born in Kenya who on 11th December 1963 are either citizen of the United Kingdom or British protected persons automatically became Kenyan citizen on the Independence Day, that is 12th December 1963. And if either of their parents had been born in Kenya at that time, then they were considered to be Kenyan citizens. Now, a person born in Kenya after 11th December 1963 automatically becomes a citizen. Anybody born within Kenya after 11th December 1963 automatically becomes a citizen of Kenya, irrespective of whether the parent is a citizen or not. And you see, this provision applies to almost all countries. That is why you find some people and they are expectant 1 month to 2 weeks to, they'll travel to another country and they give birth to that in that country. So the child that they give birth to becomes a citizen of that country. And for those like who would want to relocate, for instance, to the US, that's what they normally do. So that when they give birth to the child in the US, the child becomes a citizen as much as the parents are not. But then because the child has to be under the protection of the parents, the law now requires the US government to grant that parent citizenship so that the parent can stay and take care of their citizen in that country. And that's the trick so many people are using. And within time, they obtain citizenship of that country and they forget that. Because the law provides that anybody born in a country after the country has attained its independence becomes a citizen of that country, irrespective of the citizenship of the parents. Number two, by descent. Now, a person born outside Kenya after 11th December 1963 becomes a citizen of Kenya on the day of his birth, if on that day his father was a Kenyan citizen. Now, the citizenship by descent only applies if at that time of the birth of the person, the father was a Kenyan citizen, other than a citizen by descent, born outside Kenya, other than citizen by descent, born outside Kenya, they do not acquire the country's citizenship from the father or not, or from the parent or the father as such. Thus, paternity is given prominence in the determination of citizenship by descent. Look at the paternity. If the father was a citizen of Kenya, but the child was born outside the Kenya, then the child becomes a citizen by descent. But if the father was also a citizen by descent, then that becomes a critical consideration. The child may not automatically become a citizen by descent. Then we have by registration. Now, any woman who marries a citizen of Kenya may apply for registration and thus be granted citizenship. And similarly, a person of full age who is a citizen resident in Kenya for 5 years, who is a citizen of a Commonwealth country or a specified African country who has been ordinarily resident in Kenya for 5 years may be registered as a Kenyan citizen upon making an application for that purpose. Anyone who has resided in Kenya and is a member of the Commonwealth countries or a member of any of those specified African countries and have been resident in Kenya for more than 5 years may apply for citizenship, and then the request may be granted. And finally is by naturalization. Section 93 of the Kenyan Constitution provides that an alien may apply to be a citizen and he may be granted with a certificate of naturalization if 1, he is of full age, 2, he has resided in Kenya for 1 year before the application, 3, he has resided in Kenya for a total of 4 years during the 7 years before the 1 year in paragraph B above, before the 1 year prior to application. And 4, is of a good character. He has an adequate knowledge of the Swahili language and he intends to remain a resident if naturalized. It is important we understand that granting citizenship through naturalization is purely discretionary. The Attorney General may deny that, and when denied, you have no any recourse for that. Equally, people can lose citizenship. There are 2 ways in which citizenship can be lost: by renunciation. Now, a citizen of Kenya who is also a citizen of some other country is free to renounce his Kenyan citizenship, but he may do so only if he is of full age and capacity. Now, When one renounces his citizenship, they are required to make a declaration in a prescribed manner. Then they cease to be a citizen of Kenya upon registration of that declaration. Now, a person who is a citizen of Kenya may, a person who is a citizen of Kenya and also a citizen of some other country, at the age of 21 would cease to be a citizen of Kenya unless he has renounced the citizenship of that other country. Then the second is by deprivation. A person may be deprived from citizenship in the following cases. One, has shown himself to be disloyal towards or disaffected towards Kenya. Two, as during the war in which the country was engaged, traded with or otherwise assisted the enemy country. Three, as within 5 years of registration or nationalization been sentenced for more than 12 months imprisonment. Four, has resided continuously abroad for 7 years and has neither been in service of Kenya or an international organization which country is a member, nor registered annually at a Kenyan consulate his intention to retain the citizenship. Or one who has obtained there is registration or naturalization by fraud, false representation, or concealment of material facts. They lose that. And of course, the law also, when it comes to commercial relationship, it is important we look at the provisions of the law on persons on domicile and residence, because this would always affect, for instance, the choice of the applicable law when dealing with them in any issue. These provisions are important. You need to know where their domicile, where their residency, and which law would then apply. A person's domicile is the place where he permanently resides with an intention to remain there. That is a person's domicile. Mere residence is not sufficient to determine domicile, but we are talking of where one permanently resides and intends to remain there permanently. Then that is the domicile. The maxim of animus manenti, that is an intention to permanently remain, must be established. In order to establish the domicile of a person, the following two elements are taken into consideration. One, actual residency, and two, the maxim of animus manenti. That is the intention to remain in that place or country must be. Where these two elements coexist, a person is said to have domicile in that country. For instance, a Ugandan citizen may decide to live permanently in Kenya. In that case, then the Uganda acquires a domicile in Kenya. The law relating to domicile in Kenya is contained in the Laws of Domicile Act, Cap 37, and it provides all the capacity limitations or disabilities to different person need to. We have three types of domicile: domicile of original, domicile by choice, and domicile by dependence. We need to know all those three types of domicile. Now, a person acquires his domicile of origin at birth. That is the domicile of origin. It is acquired at birth. A legitimate child inherits the father's domicile as provided by Section 3 of the Law of Domicile Act, 7. An illegitimate child inherits its mother's domicile, Section 3, and under common law, a founding, that is an abandoned child, as its domicile of origin continues until he acquires a domicile. Then one can have domicile by choice. A man acquires a new domicile by taking up his fixed habitation in a country which is not that of his domicile of origin, as provided by Section 8. He is then said to have acquired a domicile of choice in that instance. At the acquisition of domicile of choice, then the domicile of origin is relinquished. However, the person who acquires domicile of choice may later resume the domicile of origin. And then we have domicile of dependence. It's sometimes described as the dependent domicile. A person is said to have domicile of dependence, if his domicile necessarily changes with that of another person on whom he or she depends. So the load of domicile and residence is important. A place where a person lives, whether permanently or temporarily, is the person's residence. A person's residence determines his liability of taxation. That is subject to the place where he resides, will be taxed by that law. It also determines his status in wartime. No, a person who is a resident in a country in which Kenya is engaged within a war, he'll automatically become an enemy. And so, in business transaction, it's important we know all this because it provides certain limitations, how we are relating with citizens or residents of an enemy country when we are at war with the country, so that we don't end up in a business relationship that would make us be considered as enemies of the country. Residence must be distinguished from domicile. A mere temporary stay is sufficient to constitute one a resident of a particular area, but to be domiciled in a place, one must intend to permanently remain there. Therefore, residence is just one of the two elements required to prove domicile. Why should we determine or have a distinction between domicile and residence? One, to determine the law that is applicable at the time we are entering into any contractual agreement with a party. And two, to determine whether the court has jurisdiction in a particular case. It becomes important that you understand, so that when, for instance, you get into a contractual agreement with a Ugandan and you are a Kenyan, you need to know which law would be applicable in such a relationship and which court would have jurisdiction in that particular case. Because if you register a case in a court without jurisdiction, then you are wasting. That is important. A person's family relations and movable property are determined by the law of domicile. They are not determined by the law of the place where he might temporarily reside, or he might be temporarily resident. Thus, if a domicile Englishman takes up residence in Kenya and dies in Kenya, leaving movable goods succession to the property will be governed by the government in England and not the law of Kenya. Now, regarding jurisdiction, courts usually have jurisdiction over persons who are resident within their territorial jurisdiction. Again, we need to distinguish between domicile and nationality because it also have the same legal effect. Now, while nationality is refers to a political system in the sense that a person owes his allegiance to the state, that is a national. Two, domicile refers to as a legal system. Therefore, person's family relation in these matters like marriage and divorce, legitimacy, etc., and also his movable property are governed by the law of his domicile and not nationality. Therefore, it is possible for a person to have no nationality at all. There are cases where a person have no nationality. They could be rendered stateless upon being deprived of their citizenship. But every person must have a domicile at any one. Now, it is possible for a person to have dual citizenship, that is to be a citizen of more than one country at the same time, but no one can have more than one domicile at the same time. So these are the legal aspects that we need to look at. We also need to understand what does the law provide on the persons on proceeding against the state when the person wants to keep proceeding against the state. Now, the government may commit a civil wrong just like an ordinary individual. The law relating to proceedings against the state is governed by the Kenyan Government Proceeding Act 40. So an aggrieved person has a right to sue the government for the act and default of its servants and agents. And that's why you normally see the government is sued for negligence of their servants or for an act committed. The Attorney General can be sued, or the government of Kenya, the police commissioner, the Inspector General of Police can be sued for any act that they do as agents of the government. The government is liable for its own wrongful acts, as well as those committed by its servants if the servant himself would have been liable in the first place. Section 4, subsection 1 of the Kenya Government Proceedings Act of 40 provide that the state may be sued in tort in the following cases: 1, in respect of the torts committed by its servants or agents; 2, in respect of any breach of those duties which a person owes to his servants or agents at common law by reason of being their employer; and 3, in respect of any breach of the duties attaching at common law of their ownership, occupation, possession, and control of property. And so those are the particular provisions of law with regard to persons. Any question?
Yes.
I have a question.
Yeah. Proceed.
On the accusation of citizenship, the fourth one, on your notes you said, here on your notes you have said about the nationalization. Well, in your book you said about naturalization. Does it go hand in hand, or it's more like the same?
It's the same.
It's the same.
Yes.
All right.
Any other question?
We gave an example of the application of laws of domicile, that, for example, when an English citizen is in Kenya by the laws of domicile and he dies, the property are to be taken upon or to be decided by the English state, but not the Kenyan
Yes.
state. When this Englishman had kids and maybe a family, are they treated as citizens of Kenya or citizens of the country where he came from?
You see, let me use, for instance, Kenyan, yeah? If, for instance, you relocate to the US, okay, you go there for work. Are you a citizen of US or you are a citizen of Kenya?
Of Kenya.
But where is your domicile?
In the US.
In the US, isn't it? Now,
yeah.
Are your children citizen of Kenya or citizen of US?
They are citizens of Kenya.
Yeah, unless one of them is born in the US. But if all of them were born in Kenya and you move with them for purposes of work, they are citizens of Kenya, okay? But you all become domiciles of US, isn't it? Now, suppose you die while you're working in the US. Which law would be used to administer your estates? The Kenyan law or the US law? Yeah?
The Kenyan law.
The Kenyan law, because you are a Kenyan citizen, isn't it?
Yeah.
Yeah, that is what it means. We don't use the domicile law to determine issues of succession, but you use the citizenship. That is what it means.
Okay. And we talked about citizenship by descent. I think you said, for example, if I'm a Kenyan citizen and I give birth to my child in the US, they can become citizens of Kenya, but that cannot apply to my grandchild. Was that so?
No, you see, if if you are a citizen of Kenya, you go to the
Yeah.
US and you give birth to a child, your child can become a citizen of Kenya by descent, okay? Because
Yes.
the descent, you are the father is a Kenyan citizen. And so you can only transfer citizenship by descent if you are a citizen by birth. Okay?
Yeah.
Now, your grandchild, the citizenship of the father, is it by birth or by descent?
The grandchild citizen of the, if my son's citizenship is by descent, then yeah, my son's citizenship is by descent. So my grandchild's citizenship, what will it be like?
Because your son, the citizenship of your son is not by birth but by descent, then your son cannot automatically transfer citizenship to his child. So your grandchild cannot acquire Kenyan citizenship by descent unless your grandchild is born in Kenya. In this case, then your grandchild become a Kenyan citizen by birth. While your son can lose his citizenship, your grandson cannot lose his citizenship because your grandson is a citizen by birth, your son is a citizen by descent.
So if my son is born in the US, he can become a citizen of Kenya by descent and a citizen of US by birth.
Yes.
Okay.
You see, like Obama. Obama can
Yeah.
become a citizen of Kenya if he applies, if he elects to become one. Because his father was a Kenyan citizen, isn't it? But can Obama's children, they're called the Masha and Michelle, can they claim Kenyan citizenship?
Was Obama born in Kenya?
No, Obama was not born in Kenya, but the father is a Kenyan by birth.
So he's a citizen of Kenya by descent.
If he opts to acquire citizenship by descent, he will automatically become a citizen by descent.
So the grandchildren cannot.
Sasha and Michelle cannot become Kenyan citizen unless they go through registration or nationalization.
Yeah, okay.
Yeah. But suppose Sasha or Michelle moves to Kenya when one of them is pregnant and gives birth to their child in Kenya. Then the child becomes a Kenyan citizen by birth.
And citizenship by nationalization means one lives in Kenya, or?
Yes, one living in Kenya is not a citizen, applies for recognition as a citizen, and when that application is granted, then that is citizenship by naturalization or by nationalization. Caleb says Obama can be a Kenyan by descent because of direct ancestry. That is true. Obama can become a Kenyan citizen by descent because of direct ancestry. But Obama's children cannot unless they go through either registration or nationalization or naturalization. Okay? And what is important is for us to look at the legal implication of this kind of relationship. When we get into any transaction with them, we need to look at how the law would handle such relationship. Any question? Okay, if there's none, then we take a 10 minutes break. Let's come back at 20 past. Let's continue at 20 past. We look at the next area. We look at the court systems. It's equally a wide area. So when we resume at 20 past 9, we'll look at the court system. Let's have a break. Okay, are we all back? Finas, are you there?
Yes, I'm there.
Okay. Jimmy? Jimmy, are you there? Nafula?
Yes.
Osborne?
Yeah, I'm here, sir.
Okay. Caleb?
Yes, I'm here.
Okay. Wahid? Wahid, are you there? Is Wahid in? He seems not to be in. And yet he asked a question. Is Wahid there? Wahid, are you there?
Yeah, I'm here.
Okay. You ask about the benefit of customary marriage. What do
Yeah.
you think? What do the members think? What are the benefits? You know,
I
yes?
actually don't know much. That's why I said. But I think it's kind like a deep connection to control heritage and identity.
Hmm. Some of the benefits of customary marriages includes like, you continue with family or kinship networks, Most of them are established on social recognition of marital bonds that exist within families and kinships. So there's that framework that defines the role, responsibilities, and obligations among the family members. And so it continues within that network. It also enhances cohesion, social cohesion, and community integration is an important aspect when it comes to dealing matters customary marriage. It also becomes easy to manage inheritance and management of property rights. Customary marriage would confine inheritance and property rights to the spouses and their children based on customary laws and practices. That's why we have the native lands, and when there's that customary marriage, it automatically means that the spouse, the wife, and the children become part of the inheritance of the ancestral lands. It also enhances social validation, and social validation is an important aspect and recognition. And of course, it's a way of celebrating. We have cultural celebrations and festivities. The customary marriage ceremonies would have festival occasions, filled with music, dance, feasting, traditional attires, and all that, which serves as an important cultural celebration. This, in essence, would strengthen the cultural identity of the people involved, would promote unity, would create lasting memories within the community and the likes. So, of course, it also helps in in ensuring that there is a preservation of cultural identity. So those are some of the importance of cultural. Yes, I see Caleb says deep connection and identification of culture is very true. It enhances that deep connection. So I hope, Wahid, you have
Yeah.
been helped.
Yeah, I got my answer now.
Okay. So
Thank
let's
you.
continue. We are looking at the court systems. That is our next area of concern, of study, the court systems. Now, it is important for us to understand how courts operate, because from time to time we may find ourselves in these courts. What is important for us to understand is their jurisdiction. What is the jurisdiction? Because we have different cases, we have different issues that will need the intervention of the court. What we need to understand is the jurisdiction of these courts. Whenever we have an issue, we must determine the jurisdiction. Now, the Kenyan court, has a structure that enables them to operate at different levels. And the court at all these different levels have powers to deal with certain cases, which are described as the jurisdiction of the courts. And so if we present a case to a court that is outside the jurisdiction of that particular court, then we may not receive justice, because they can only handle cases that are falls within their jurisdiction. Now, the Kenyan court system is based on the Constitution and the other acts of parliament, such as the Magistrate Courts Act, such as the Judicature Act, Kadis Court Act, etc. And so these are what governs the operations of the court systems in Kenya. They inform what the courts can do. They inform the jurisdiction. They inform the mandate. Now, what we need to understand is that not all courts are of equal jurisdiction. Not all courts are of equal mandate. And therefore, we cannot say any court can handle any case. We'll be coming across several cases, but then you realize that different cases can be handled by different courts. Different courts have different jurisdiction over the cases that we are going to handle. The system consists of both subordinate and superior courts. We have subordinate courts and superior courts. You know, we have superior courts such as the Court of Appeals, such as the Supreme Court, such as the High Courts. And then we have subordinate courts, such as the resident magistrate courts, the Kadis Court, the Chief Magistrate Courts. They are regarded as subordinate courts. Is the aspect of superior and subordinate is with regard to their jurisdiction and the powers that they have in handling different cases. Now, you see, in looking at the court system, we've said that the courts operate at two levels, the superior courts and the subordinate courts. Now, the important aspect in the structure of courts is one, the structure, which essentially addresses the hierarchy or the level of courts. This is important because it determines their jurisdiction. And the second is the establishment, which deals with the composition and who presides in that court. The composition and who preside in that case, in that court, would determine the kind and the nature of cases that the court can handle. You know, there are cases that the magistrate cannot handle. There are cases that must be handled by the judge of the appeal court. There are cases that can only be handled by the Supreme Court. And so establishment in terms of the composition and who presides over the courts is important in helping us know where to register a particular case, should we be in need to register one. The jurisdiction of courts is equally important. You know, The jurisdiction of court refers to the powers of different courts to hear and determine disputes. It is the power of a court to hear or entertain a particular case. And as I said earlier, not every court can hear every case. And therefore, for a court to hear a case, that court must have the requisite jurisdiction. When we talk of jurisdiction, we can be talking of geographical or territorial limits of the powers of the courts, or the functional powers to hear original matters or appellate matters, or both appellate and original matters, or subject matter, whether it is a civil or criminal justice in case, or pecuniary, which has got to do with the range of monetary or financial value of the subject matter. All these will determine the jurisdiction of the court. So we need to understand the jurisdiction. We have 4 types of jurisdiction. One, original jurisdiction, which is the power of a court to hear a case for the first time. It is important that we understand that we have courts that are authorized to hear cases for the first time. And there are courts that would not hear cases for the first time. They may hear cases on a second time or appellate level. And so they can only deal with appellate issues. Like the Court of Appeal can only deal with, they don't have original jurisdiction. They do not have power to hear a case at the first instance. You know, high courts, resident magistrates court, district magistrate courts, Kadi courts, all have the original jurisdiction. They have the power to hear a case at the first instance. But the Appellate Court of Appeal and the Supreme Court do not hear cases at the first instance. Then we have our appellate jurisdiction, which is the power of a court to hear a case on appeal. Now, an appeal is where a case has previously been heard by another court or a tribunal of lower jurisdiction, and they are not satisfied, and so they move to the next court in the next level. That is the appellate jurisdiction. Then we have territorial jurisdiction, the power of a court to hear or entertain criminal or civil cases from within a defined geographical area, which is normally referred to as the judicial district. You know, like a high court sitting in Eldoret has jurisdiction to hear cases within the Eldoret judicial district. There is high court sitting in Kisumu has jurisdiction to hear cases within the Kisumu judicial district. High court case sitting in Nakuru, in Mombasa, and all these major jurisdiction districts would have mandate to hear cases within those jurisdictions and not beyond those jurisdictions. They can only hear cases from within those districts in which it has been established. In the same case, a Kaddi's court can only hear cases from within the province for which that Kaddi court has been established. Then we have pecuniary jurisdiction, which relates to the monetary or financial jurisdiction, the power of a court to entertain civil cases whose value of subject matter would not exceed specified maximum amount. For instance, Chief Magistrate Court has a jurisdiction to hear cases whose value, to hear cases whose subject, the value of the subject matter would not exceed 3 million. Then senior principal magistrate is restricted to 2 million, principal magistrate 1 million, senior resident magistrate 800,000, and resident magistrate would hear those up to the value of 500,000. And so that is pecuniary jurisdiction. It is also important we understand the structure of the court in Kenya, the structure of the judiciary in Kenya, the hierarchy of the courts. You know, would include at the apex, we have the court, the apex courts, we have the Supreme Court that is headed by the Chief Justice as the president and the deputy as the deputy Chief Justice and the Supreme Court judges. Then we have the Court of Appeal, who as a president, one of the judges is appointed as the president. And then we have the High Court at the third level. Now, at the apex, we have the Supreme Court and the Court of Appeal, with the Supreme Court being at the higher level than the Court of Appeal below it. Below the Court of Appeal is the High Court, headed by a principal judge. Then we have, under the High Court, we have the Qadi courts, we have the court martials, we have the resident magistrate courts, we have the district magistrate court, we have the district magistrate court of first class, and then we have district magistrate court second class. Then we just we have the below the district magistrate court first class, we have the district magistrate court third class. All these have their different, and that is what is important for us to understand. What are their jurisdiction? What can they determine? Which cases can they handle? In addition to this, we have the industrial court, we have the environment and land court, the magistrate court, the Qadi's courts, the court martial, and the tribunals that are established by the Act of Parliament. They are all part of the structure of the court systems in Kenya. We have the superior courts, which is the Supreme Court. Supreme Court is established under Article 163 of the Kenyan Constitution, and it established that it shall consist of the Chief Magistrate, who is the President of the court, the Deputy Chief Justice. It comprises the Chief Justice, who is the President of the court, the Deputy Chief Justice, who shall deputize for the Chief Justice and be the Vice President of the court. And then it has five other judges. It has 5 other judges. In total, the Supreme Court has 7 judges. Sorry, there's an interruption. So we have those different types of courts. We are looking at the Supreme Court. We look at this, the composition. What is important is also looking at their roles and the functions. That determines what they can do and what they cannot do. We need to understand what are their roles Then we have the Court of Appeal. No, Court of Appeal is established under Article 164 of the Kenyan Constitution. And he said it shall consist of the number of judges being not fewer than 12, or as an act of parliament may prescribe, and shall be organized and administered in the manner prescribed by an act of parliament, the Court of Appeal Organization and Administration Act. And it provides that there shall be a president of the Court of Appeal who shall be elected by the judges of the Court of Appeal from among themselves. What is the jurisdiction of the Court of Appeal? It is primarily an appellate court with the jurisdiction to hear criminal and civil appeals from the High Court. They can only hear cases of appeal from the High Court, meaning resident magistrate court cases cannot go to the Court of Appeal for hearing. From the district magistrate courts or resident magistrate courts, they can appeal to the High Court. They proceed to the High Court, and they can only get to the appeal court from the High Court. That is the jurisdiction. They have an appellate jurisdiction. It is an appellate court. However, the court exercises very limited original jurisdiction in that it is empowered to punish contempt of court, and it has the jurisdiction to stay the execution of an order of the High Court pending an appeal. The Court of Appeal is a superior court of record, therefore it sets precedent. So it provides some precedent cases as one of the sources of law. Remember, we said precedent is one of them. And so the Court of Appeal has that powers. We also have the types of judgment by Court of Appeal. It can be unanimous judgment or it can be a judgment, majority judgment. And also the powers of the court is important. You look at the powers of the court. Now, some of these you can read them because they are fairly straightforward. Powers of then we have the High Court, which is established under Article 165. And it says it shall consist of the number of judges prescribed by an act of parliament. Currently, no more than 200 judges according to the High Court Organization and Administration Act, and shall be organized and administered in the manner prescribed by an act of parliament, the High Court Organization and Administrative Act. There shall be a principal judge of the High Court who shall be elected by the judges of the High Court from among themselves. The composition of the High Court, the judges of the High Court are known as the pushing judges and are the Chief Justice and such other numbers as prescribed by the Parliament. Its jurisdiction, it has both original jurisdiction and appellate jurisdiction. In original jurisdiction under Section 60, subsection 1 of the Constitution, the High Court has unlimited original jurisdiction in criminal and civil cases. And then on appellate jurisdiction, it entertains criminal appeals from the resident magistrate courts and from the court martials and from the district magistrate courts of first and second class orders. It can also entertain appeals in civil cases from the resident magistrate courts, the Kadhi courts, and the district magistrate courts of first and second order, and also tribunals subject to appeal, such as the Red Tribunals. The other roles of the High Court include interpretation of the Constitution, provided for by Section 67, subsection 1, then enforcement of fundamental rights and freedoms under Section 84, subsection 1 of the Constitution. It has original jurisdiction to enforce fundamental rights and freedoms of the individual. It also has jurisdiction over parliamentary election petitions. The High Court shall have unlimited original jurisdiction in criminal and civil matters. The High Court has jurisdiction to determine the question whether a right or a fundamental freedom in the Bills of Rights has been denied, violated, infringed, or threatened. The High Court also has jurisdiction to hear any question with respect to the interpretation of the Constitution including the determination of the question whether any law is inconsistent with or in contravention of the Constitution, the question whether anything said to be done under the authority of the Constitution or of any law is inconsistent with or in contravention of the Constitution, any matter relating to constitutional powers of state organs in respect of county governments, and any matter relating to the constitutional relationship between the levels of government, and the question relating to conflict of laws under Article 191. Then the High Court does not have jurisdiction in respect of matters reserved for exclusive jurisdiction of the Supreme Court under the Constitution or falling within the jurisdiction of the courts contemplated in Article 162, subsection 2. The High Court has supervisory jurisdiction over the subordinate courts and over any person, body, or authority exercising a judicial or quasi-judicial function. But it does not have supervisory jurisdiction over a superior court, namely the Court of Appeal and the Supreme Court. High Court has got special powers such as supervisory jurisdiction. The Constitution confers specific powers on the High Court to exercise supervisory jurisdiction in any civil and criminal proceedings before subordinate courts, and may make such orders, issue such writs, and give such direction as may consider appropriate for the purposes of ensuring that justice is duly administered by such courts. And in invoking the supervisory jurisdiction of the High Court, we have two prerogative orders that can be given, the mandus order and the certiorari order. Now the mandus, the literal meaning of mandus is we command. This is an order issued by the High Court to any person or body commanding him or them to perform a public duty imposed by law or state, where certiorari is a term meaning to be informed. An order issued by the High Court directed at an inferior court body exercising judicial or quasi-judicial function to have the records of the proceeding presented to the High Court for specific purposes such as to secure an impartial trial, to review an excess of jurisdiction, to challenge an ultra vires act, to correct errors of law on the face of the record, and to quash a judicial decision made against the rules of natural justice. They can also issue prohibition orders. They can issue writ of habeas corpus. Habeas corpus simply means produce the body, dead or alive. When, for instance, when police hold individuals and they are not committed to court, then the High Court can issue a writ of habeas corpus requiring the police to produce such a person within an stipulated time. They also have powers to interpret the Constitution, and they also have powers to hear matrimonial cases. The decision of the High Court can be appealed against in the Court of Appeal. And of course, we have several divisions of the High Court to handle the different cases. We have the Family and Children Division, the Commercial Division, the Admiralty Division, the Civil Division, the Criminal Division, the Constitutional and Human Rights Division, the Judicial Review Division. And of course, the Chief Justice may establish any other division on the advice of the principal judge of the High Court. Then we have the Employment and Labor Relations Court, also known as the Industrial Court, which is a superior court of record with the status of the High Court. It is established pursuant of Article 162, Subarticle 2, Paragraph A. And the purpose of setting up the Employment and the Labor and the Employment and Industrial Relations Court is to handle disputes and the furtherance, securing and maintenance of good employment and labor relations in Kenya. So matters of labor relations, they handle a number of labor-related issues such as disputes relating to or arising out of employment between an employer and an employee, dispute between an employer and a trade union, dispute between an employer's organization and a trade union's organization, dispute between trade unions, dispute between employer organizations, disputes between an employer's employees and employers organization, dispute between an employers organization and trade union, dispute between trade union and the members thereof, dispute between an employers organization or a federation and a member thereof, dispute concerning registration and election of trade union officials, dispute relating to the registration and enforcement of collective bargaining agreements, and all those. So they have all that jurisdiction. Those are areas that the employment and industrial relation courts have the jurisdiction over. It will also have appellate jurisdiction. The Employment and Labor Relations Court has appellate jurisdiction. It shall have appellate jurisdiction to hear and determine appeals from one, decision of the registrar of trade unions, and two, any other court, local tribunal, or commission, and prescribe under any written law. Now, the decision of the courts are known as awards, and they are deemed to be final under Section 17, subsection 1 of the Trade Dispute Act. An award cannot be appealed against, stayed, restrained, or be reviewed. An award must be published in the Kenya Gazette, whereupon it is effective. The court also maintains a register of all collective agreements that are registered by it. We have the Environment and Labor Courts. It is one of the courts that has been contemplated by Article 162, sub-article 2. It is a superior court, just like industrial court is also a superior court. It has the status of High Court. It is established under Section 4 of the Environment and Land Court Act number 19 of 2011 and has jurisdiction to hear any dispute relating to environment and land. Then we have the subordinate courts like the magistrate courts with both criminal jurisdiction and civil jurisdiction. Then we have the Kadis Court. We have the courts martial, that is, now the Kadis Court is established by Section 4, subsection 1 of the Kadis Court Act, Cap 11, pursuant to Section 63, subsection 3 of the Constitution, which provides for the establishment of subordinate courts and held by a Kadi. The Kadis Court under Article 170 of the Constitution shall consist of a chief Kadi, and such number being not fewer than 3 of other Kadis as may be prescribed under an Act of Parliament. The court martial is established by Section 85, subsection 1 of the Armed Forces Act, pursuant to Section 4, subsection 1 of the Constitution. It is a subordinate court, and they only hear cases involving people serving in the military under the Kenyan Defense Forces Act. Then we have tribunals. We have tribunals, which are bodies established by acts of parliament to exercise judicial or quasi-judicial functions. Tribunals normally supplement ordinary courts in the administration of justice, but they do not have penal jurisdiction, and most of them are under the supervision of the High Court. It is important we understand that all tribunals must be governed by the principle of natural justice. That is, a person shall not be condemned and erred. 2, no person shall be judged in his own case. We have a number of tribunals: industrial court, rent tribunal, business premises tribunal, Insurance Appeals Tribunal under Insurance Act, land tribunals under Section 9B of the Magistrates Court Act. You have the Capital Markets Tribunal under the Capital Markets Act, and it also provides for the operations. I want you to read more about the tribunals. It is also important you look at the appointment of judges, the appointment of Chief Justice, the qualifications, the functions of the judges, the function of the Chief Justice, appointment of magistrates, appointment of Kadis Court, the role and the functions of the Office of the Attorney General. It is important that you look at all those because they have serious implication in the conduct of our businesses. So in brief, that is what the court system is all about. When it comes to public law, we are looking at the law that governs the relationship between the state and its citizens. It consists of the constitutional law, the legislative, the judiciary, and the executive. And all of them are different functions of the government and the arms of the different functions of the government. And key in the public law is the principle and concept of the Constitution. It plays a key role. The understanding of the Constitution is key. It defines the relationship between the government and the citizens. It determines the organization of the country, the state. It also determines the distribution of powers among the various state organs. So in public law, the Constitution plays an important role. In determination or in the administration of public law, the rule of law plays an important role, and the doctrine of separation of power, so that each organ, each state organ gets to understand the role that they are supposed to play in the judicial process. That is important. That is an important aspect of public law. Each organ, each state organ should be able to play their role in the judicial process. The administrative law set out the functions of the executive, the public authorities, special tribunals, statutory inquiries, delegated legislations, role of the courts, and the legislative powers. Those are very important aspects of the public law, which we need to understand. In the administration of justice, public law plays a very prominent role. We cannot ignore it, and it's important. It also defines criminal law. It is important that you understand that public law, to a great extent, defines criminal law. It defines how proceedings should be undertaken when it comes to the matters of crime. It talks of different types of crimes and how they can be addressed within the judicial and the quasi-judicial systems. So that's about the public law and its importance, what we need to know. Any question? Any question on the court systems and the public law? Okay, then if there's none, then we'll stop there. Our next class will meet on Monday. Our next class will be on Monday. When we meet on Monday, we'll now move to part 2 of this course. We are done with the part 1, which is introduction to law. We'll move to part 2, which is basically the mercantile or commercial law. So the remaining bit will all focus on the mercantile law. We'll start by looking at the law of tort, so you can read ahead. So on Monday, we'll be looking at the law of tort. And then Monday, we look at the law of tort. On Tuesday, we look at the law of contract. On Wednesday, we look at contract of employment. And then on Thursday, we look at the law of agency. And the remaining we'll look at next week. Okay, any question? Okay, if there's none, then we adjourn. Let's meet on Monday.